dealt with discovery issues. We had plenty. I think we had. I don't want to pass up any discovery that I would have been entitled to. I think there were some issues here that required the case not only to be reversed on the plea of the jurisdictional issues, but also because of issues that weren't addressed in the plea of the jurisdiction. For instance, the third pleading, the third amended pleading, raised issues of equity, raised issues of declaratory judgment, raised issues of injunction, and neither of those were addressed by the county. But what happened is when we went into the plea of the jurisdiction dealt with, as you see in the reporter's record, it dealt with the fact that the county contended that we had incurably missed administrative deadlines, which is not true. And you can look at TCRP 4, and you see that that she was fired on June the 1st. The statute then says that you start counting from June the 2nd. You see that we had 90 days, which ended on August the 31st. Excuse me for the allergies I fear that I have, and on top of that, we appealed and asked for it on August the 30th, but they denied that appeal on August the 31st. But we didn't know about that till September the 13th, thanks to them telling you about it in the plea of the jurisdiction, where they attached the green card that shows that we didn't receive that until September the 13th. So I filed a lawsuit on September the 11th, timely filed. On the DCHRA, we filed the charge of discrimination on June the 22nd, well within the 180 days. We filed we received the right to sue letter on, I think it was August the 2nd of 2019, and I filed a lawsuit, I think, within 3 days after that. So we didn't miss any timelines. Now, what did the judge want to know? The judge wanted to know, if you read the record on appeal, the reporter's record, the judge was more interested than not in, well, were any of these complaints on the whistleblower, were they in writing? Well, they don't have to be in writing. As you know, any report, whether it's oral or written, is a report. The county would say, well, it's a matter where we really settled this stuff before trial. We settled it out of court. That's not true. That's false. That the first time that the word settlement ever came up was in the argument of the plea of the jurisdiction before Judge Hawkins. It was never settled. What happened was they gave a general discharge. They told the state, as they're required to do in the Form 5 separation document, they told the state that my client was given a general discharge, which meant that she was under investigation for who knows what, everything except killing Lincoln. And the point was that they then came along on the day that was set for trial, when we were with our witnesses ready to go to trial, and so they called and said, look.
Who did Ms. Patel make the report to?
I'm sorry, Your Honor.
Who did Ms. Patel make the report to?
She made these reports to, first of all, to Sylvia Trevino, and she made these reports to Sergeant Ronnie Powell, and Ronnie Powell was a deputy constable sergeant who was brought in by Sylvia Trevino to be a supervisor for Ms. Patel as her training officer on January 4th, 2017.
Did either of those people have the opportunity to take, or the authority to take corrective action with respect to that, to resolving the problem that Ms. Trevino,
A constable, as I recall, has authority under the Texas government code, and I wrote it down so that I wouldn't forget it, that the 36, I was thinking, and 30, I think it's 36. The constable has the authority to enforce the law and to take whatever action is necessary to remedy a violation of the law. This guy was a constable. He was a sergeant. He was brought in to train. He was a deputy constable in Precinct 1 under Al Rosa. He, in fact, was was asked by Patel on both March 5th, order about March 5th, 2018, and April 28th, March of 2018, to report this up to his chief deputy, Carl Shaw. He did assure Patel that he had done that. On April 28th, he assured that he had reported it up to Carl Shaw. I think 80182D, I think that hearsay doesn't block his testimony, or doesn't block her testimony about what he told her. And
Counsel, what evidence did you provide in response to the plea to the jurisdiction?
what did I provide?
Yes, sir.
I provided about everything that we had. Excuse me. What I provided was the fact that we had it's all in the record, the clerk's record, and I apologize for not having memorized the point, but they provided and what was necessary, and we supplemented what was necessary. We provided the fact that Patel had indeed been terminated. We provided the fact that the issues that she had reported this orally, or affidavit, her deposition, everything that was necessary, I think, to show that the court had jurisdiction.
So,
gosh, you got me on that one.
So I don't recall seeing in the record any attachments of any evidence to your response to the plea to the jurisdiction.
I think there was evidence. In fact, there was the evidence. We had an affidavit from Rebecca Bowden, who teaches constables from the state of Texas on how to behave as constables. We had other evidence in there. We had a number of items of evidence that were attached to the clerk's, to our response that are in the clerk's record. And I only know that freshly because I should have remembered that. But so back to the point. They never were able to deal with the fact that she wasn't fired for a non-discriminatory or a non-retaliatory reason. And we know that because they told the state that. And they say, well, but that was just a settlement. I challenge you to find the word settlement anywhere in the motion to dismiss, which they drafted and sent to me. I challenge you to find anything in there that indicates that it was any more than a decision by the county to capitulate, to do that she asked them to do, which was change the general to an honorable. And if she wasn't entitled to an honorable, then they should have not lied to the state and said that she was entitled to it. The question then,
Mr. Watts, your time is up. Are there any more questions from the panel?
please forgive me, I'm sorry.
No problem. Mr. Hopkins?
Good afternoon, Your Honors. May it please the Court, I'm Seth Hopkins, representing appellee Sylvia Trevino. Justice Kelly, you asked the question a moment ago what the standard of review is. The Texas Supreme Court holds under Texas Department of Wildlife versus Miranda that when a public entity gives evidence to challenge the pleadings, existence of jurisdictional facts, or both, the plaintiff must respond with evidence to raise at least a genuine issue of material fact to overcome that. So in other words, the real issue today is whether there's any genuine issue of material fact that Ms. Patel was fired for the 12 reasons documented on pages 51 to 54 of the record. There's not. I'll address first the facts and then each of Ms. Patel's claims. This case was filed September 11, 2018, and discovery was active for more than a year. Ms. Patel had every opportunity to depose witnesses, secure affidavits, and develop facts, yet she failed to do so. As I'll explain in a moment, most of the allegations that you've heard today are unverified statements made by counsel in pleadings, and many weren't even made until after the summary judgment ruling was heard and the final judgment was signed. The record evidence shows that this is a case about a police officer who was fired 3 times from 2 different agencies for blatant misconduct each time. First, she was fired from the Precinct 7 Constable's office in 2013 for pushing an older colleague out of a chair and sending emails that, in the words of Constable Meg Walker, tried to cause a, quote, rebellion against the department. In 2014, Precinct 6 Constable Martinez agreed to hire her, but within a year she was forced to resign for having a very public affair with one of her colleagues. On January 1st, 2017, Sylvia Trevino was elected Constable of Precinct 6. On her first day of office, she gave Ms. Patel a third opportunity to be a peace officer, but Constable Trevino warned Ms. Patel that she wouldn't tolerate any sort of misconduct. 3 days later, after she was hired, Ms. Patel was assigned to work with a sergeant from Precinct 1. That very day, she began an affair with that sergeant. Constable Trevino learned about this and asked Ms. Patel if it was true. Patel denied the affair, and Constable Trevino gave her the benefit of the doubt. But soon her conduct, Patel's conduct, both on and off duty, grew so egregious that she just couldn't ignore it
Counsel,
anymore.
may I ask a question
Yes.
about that? What does the alleged affairs have to do with Ms. Patel's employment?
Well, first of all, it's in the rules for the police officers. They're not supposed to, because of the nature of their work, they're not supposed to have affairs with colleagues. But the real issue came when she kept misrepresenting the affair. It came with some very public fights that happened with the person she was having an affair with. It wasn't even so much that she was having the affair. It was the fact that it was disrupting both her office and the office of Precinct 1. That was the real issue that arose. Okay.
So your contention is that the repeated rules violations were the proximate cause of her discharge?
Absolutely. 12 specific rules violations.
And not the whistleblowing?
That's correct.
And wouldn't that be a causation question for a jury to weigh?
Well, it's a causation question, but first of all, when we raise the evidence, then it's up to the plaintiff to be able to respond with evidence in kind. There was, as you correctly pointed out, there was no evidence. No evidence at all except there were 2 attachments to the response to the plea of the jurisdiction. There was her right to sue letter, and there was her charge with the EEOC. Neither of them were verified. That's it. That's the only timely evidence that was presented, and it wasn't even evidence. So she failed to meet her burden of even meeting the prima facie case, much less to put anything on to suggest there's a fact issue. So it's treated like a summary judgment.
But you did just say that one of the causes for her discharge would be the whistleblowing, didn't you? Or
No, Your Honor.
No, you just said it's only the rules violations, and there's no evidence of any whistleblowing?
There's no evidence of any whistleblowing. We're not even clear. Apparently she complained to her boyfriend, and not in a capacity that she wanted anything to be prosecuted. She was just venting to her boyfriend. She's a licensed peace officer. She knows that if she wants to file a complaint, she can go to the district attorney, she can make a formal report. Just saying in your off hours to your boyfriend that you're unhappy with your boss, even if that were true.
I'm sorry, did she also not say that she was concerned about violation of probation by a convicted felon?
That's correct, but according to the
And that's just complaining to a boyfriend?
Well, according to the whistleblower statute, number one, it has to be a violation by a public employee. He wasn't a public employee, he was a private citizen. It also has to be brought to an appropriate law enforcement.
I think she was complaining about the behavior of the constable, not the behavior of the felon.
That's not clear from the record, from the way that I read it. She's upset with her husband. And she didn't go,
I think she was upset with the wife for allowing the husband to violate the terms of his probation.
Wasn't clear in the record, and it's certainly, if she doesn't meet the elements necessary under a whistleblower, she didn't report it to an appropriate law enforcement agency. She didn't ask for a formal report. She's a peace officer. She knows what it takes to prosecute.
We understand she's a police officer, but how do you define the appropriate agency, appropriate authority?
She could go to the district attorney. She could go to the Texas Ranger.
She could, but is reporting to another constable, is he an inappropriate authority?
It's inappropriate because she would have to file a report. She would have to do something formal.
You're saying it has to be in writing?
It has to be to someone.
I don't believe that's in the statute, is it?
It has to be with the intent of prosecution. And there's no indication, even in her own words, that she intended for this to be prosecuted. She also never identifies a statute that was violated, that the private citizen violated. There's no criminal statute that she identified.
Violation of probation is not clear?
So, but first of all, his probation, but she hasn't identified what statute that she believed Constable Trevino violated. So in other words, you have to identify a criminal statute that you expect can actually be prosecuted, and that never occurred in this case. But even then, none of this was in the record. I mean, she didn't put on this evidence. She could have signed an affidavit explaining all of this, but the burden is upon her to overcome all of these rules violations that we identified. Other rules violations that were really important. Business owners, she went into a business just a few months after she was employed, and business owners will let deputies put their cards as a contact, as sort of a public service, walked into the business, took the card out, ripped it into pieces, and announced to an entire restaurant, she's in charge now. She had a huge fight with her boyfriend, and left without even paying for her meal. Her boyfriend understood that this was likely to result in prosecution, so he went and he reported to his supervisors like he was supposed to. She did.
May I ask about
Sure.
that, the incident at the restaurant is what you're referring to, correct? The BJ's
Correct.
restaurant?
That's correct.
So, from the record, it's not clear to me what Ms. Patel did that violated any rules in that incident. It seems to me that her friend did have reason to think that he had done something wrong, but I don't see where she believed that she had done something wrong in
She
that
left
instance.
without paying. I mean, she was also involved in the altercation. She left without paying, but the real issue is that when she found out, she was supposed to report something like this to her supervisor, a public incident that could result in a crime. She didn't. That was one of the rules that she broke. And then what was really disturbing is that she was being investigated by Precinct 1 because of the incident. She was supposed to report that to her supervisor. She didn't. Constable Trevino finds out from a colleague that another department is investigating her employee. And when she finds out, when Patel finds out about the investigation, she goes to the restaurant in uniform and harasses the kitchen employee, tries to intervene in the investigation and get the surveillance tape for herself. That was an egregious violation, trying to interfere with another department's investigation. Any of these are grounds for termination. And certainly she was terminated for far less in her 2 previous jobs as a deputy constable. So those were all very, very valid reasons. So, and another concern is that she kept misrepresenting about the affair to Constable Trevino. And you see in the record, even today, her story keeps changing. Sometimes she denies the affair, sometimes she admitted. Under oath, she signed 2 statements with Precinct 1 denying the affair. And then on pages 58 and 59 of the record, you see that she sends a long email to a supervisor at Precinct 1 admitting 3 times, in all caps, using a total of 6 exclamation points, that she was having an affair with their sergeant since January 4th, 2017.
Would you mind reading that part of the email? Did she
Sure.
say that they were dating?
I don't have that part right in front of me, but I can tell you it's pages 58 and 59 of the record. She says they were dating, and the quote that I have is, she boasts that, quote, she would have been more than glad to show all the beautiful memories she shared with their employee, and she said that they had been dating. So she made very clear. So she's giving contradictory statements. We trust our law enforcement agents to tell the truth above all else. You get on a Brady list if you're caught lying under oath. So that alone is a reason for termination. There are so many reasons that Ms. Patel could not keep her job. So Ms. Patel's live pleading, the question was asked about what discovery was presented. Her live pleading is her first amended petition filed May 23rd, 2019.
Why is the 3rd amended petition not the petition that we should be looking at right now?
Because it was filed the day of the hearing on the plea to the jurisdiction, and under Texas Rule Civil Procedure 63, you either have to have leave of court or you have to file within 7 days of a hearing. And so Ms. Patel has suggested that rule doesn't apply to summary judgment, but that's not what this court held in Mensel-Willett v. Smith International, or the 14th Court of Appeals held in Cheab v. Edward Development. Says that Rule 63 applies to summary judgment, and a party must have leave to amend within 7 days of hearing. And while there can be a presumption that the court considered amendments filed prior to the hearing, anything filed after summary judgment is absolutely barred. What that means is, starting at page 203 of the record, You can't look at anything else. The trial court couldn't look at it because the judgment had already been signed. You couldn't look. You can't look. The third amended, even if we give her the benefit of the doubt, and let's assume for a second that it was accepted, that was also only 10 pages long. It still contained no verified facts except an untimely expert affidavit from an expert who had never been disclosed the day of the hearing. She was a former chief deputy constable from another county giving her personal opinion that any investigation against Patel was, quote, legally null and void. That's it. That's the only verified information ever that Ms. Patel has provided. That's just not enough to overcome her burden under Miranda.
Can I ask you, assuming everything you've said is correct about Ms. Patel and her conduct, does that mean we should not listen to complaints about violations of probation?
Oh, absolutely. There's no question, but they need to be properly reported. She could go into precinct 1 and say, I'd like to file a complaint, and that would be fine. But sitting there at dinner with your boyfriend and just complaining about your boss, that it has to be a legitimate attempt to have something prosecuted, not venting to a social acquaintance who happens to work for a law enforcement agency.
Where in the statute does it say that?
Well, it doesn't. Well, what it says is it has
that
to
we're
be,
kind of constrained by the terms of the statute.
But the statute does use the word an appropriate law enforcement agency, and
Right.
It's understood that it's with the intent of prosecution. That's the whole point of the whistleblower.
Well, it's understood by whom?
That's the purpose. That would
Okay,
be
so with the intent of prosecution, wouldn't that be a state of mind?
Okay.
And wouldn't that generally be a question for the jury?
But there would have to be some objective facts to support that. If she had signed an affidavit saying, I told my boyfriend because I wanted him to do something about it, then we might be in a different situation today. But there's none of that in the record. That's the crucial distinction in this case. And the whistleblower statute, there are a number of elements that she has to meet. Again, first, she never alleged that it was she never explained what she thought, what law she thought Constable Trevino could be prosecuted.
What
for.
stage of the proceedings does she have to give a specific legal citation?
At least before the plea of jurisdiction heard, I would think. She could easily in her...
I'm just trying to figure out when you were saying she needed to have done this by. Did she need to do it when she first made the report, when she was being discharged, when she filed suit, or here on appeal?
At some point before the plea of the jurisdiction, I would think.
Before the signing of the order on the plea of the jurisdiction, or the hearing on the plea of the jurisdiction, or when?
Certainly before the hearing.
Did you ever file special exceptions?
I don't believe we did. I believe we just filed the plea of the jurisdiction.
Did you ever attempt so there's no attempt to clarify the pleadings and to, if they were vague, say, as to what statute was being violated, you didn't request that Ms. Patel replead to give that specific notice?
Well, again, under Miranda, our burden is just to come up with facts, and it's her burden.
I understand that. I'm just talking about solely with regard to the pleadings.
Correct.
You did not make that request. You did not file special exceptions, nor request it be repleaded, or that the causes of actions be struck, absent repleading.
That's correct. But after all these amendments, certainly nothing prevented Ms. Patel from doing that.
But that's not the question. Nothing prevented her from doing that. But did you, preserve the error, if it were error?
I think we preserved the error with the plea of the jurisdiction.
Okay.
Are there any other questions? We ask the court to affirm the district court. Thank you.
In answer to your earlier question, when Judge Gere, the pleading states each of the elements. Before Bland versus Blue, you will recall 2000, sort of set the way the pleas of the jurisdiction were going to be handled. And before that time, in his comments in that case, then Chief Justice Tom Phillips pointed out that the only time that you used evidence was to show where fraud had been used to obtain jurisdiction. In that particular case, Chief Justice Heck said, well, but we're going to go a little bit further. It seems like you ought to be able to be able to require evidence on the prima facie elements of the case. In this particular case, by the way, 63, this is not a pleading to the jurisdiction. A pleading to the jurisdiction is not a pleading to jurisdiction is not a pleading that requires advance notice. Number two, they never objected to the third amended petition. Never objected. Number four, they never filed special exceptions. In terms of all these nice little trashy stuff, things that they bring out and say she was fired by 3 agencies? No, everybody was fired. First of all, she and Sylvia Trevino were both fired by May Walker. Sylvia Trevino was fired for being dishonorable. You've got that as part of my proof in my elements of the letter from May Walker that fired Sylvia Trevino for being dishonorable, in a dishonorable way. Number 2,
but
you have...
Counsel, if you haven't verified any documentation...
It's a governmental record, Your Honor, and as a governmental record, it does not have to be verified. It constitutes in and of itself a verification because it is a letter of termination of Sylvia Trevino dishonorable. The fact is, it may question her ability to hold office.
Excuse me, sir, but did you verify that, did you get a certified copy? Did you verify that it was an accurate copy of the letter that you attached?
I verified that it was an accurate copy. Did I get a certified copy? No, I did not. That I could do from TCOL, I suppose, but that would have required, certainly, I think that since it is the most available version, it's the most available evidence out there. If they're denying that she was fired dishonorably by May Walker, that blows my mind. Number 2, my client was not fired particularly by Henry Martinez because of the fact that she did anything else. She was the last person let go. He let go of everybody that had worked under Victor Trevino. When Henry Martinez came in, he let go of everybody. My client was let go the last. In terms of being terminated here, he says that I showed no evidence that there was the pleadings show the jurisdiction. He says that the evidence that I'm obligated, that my client's obligated to say, here's the statute that she violated. And it's very clear that she charged Sylvia Trevino with abetting her husband's violation of the terms of probation, the community service.
I'm going to switch gears because we're running out of time. So, Ms. Patel was terminated based on specific rule violations, according to the record.
No, she wasn't.
How do you disagree, and what's your basis for disagreement?
The basis of my disagreement is they signed an official document which they produced to the court, to Judge Hawkins, which said she wasn't. They signed a separation form 5, and they either lied, like I said at the hearing, they either lied to Judge Hawkins or they lied to TCO. You can have your choice. In TCO, they gave her an honorable discharge. If you're an honorable discharge, you didn't violate anything. They came along, and what they're doing today in their argument is they're ginning up stuff that is contrary to the record. I know you've read the record, but please look at the petition. The petition, the 3rd amended petition, or the 4th, even the 4th. You say, well, why did you file the 4th, Mr. Watts? Because there was still plenary jurisdiction, and I felt like Judge Hawkins might, if she saw the record, she'd become less enamored with the fact that there had to be a written report. There doesn't have to be. By the way, the statute that you've asked about, Judge Kelly, the statute that was violated by Sylvia was 7.062A. Abetment. They said, well, you can't. He says, I couldn't find in the record where Ms. Patel charged the constable with a look. It's all over there. It's all over the record. The record shows, and the petition shows, that my client said that Sylvia Trevino was helping her husband violate the terms of his probation by Judge Brown. He was violating by being in the office and running the personnel and running decisions. He was running the show. He was a shadow constable. And and my client knew that if Judge Brown, and by the way, Judge Brown did call her. How do I know that? I was sitting there talking to her about this case when Judge Brown called her on her cell phone. But that's in the record, by the way. That's in the record. This is an amazing case in that you have my client who found the constable not only to be dishonest, but to be dishonest about the most elemental things.
May I ask
Well,
a
so no,
question
please.
also, since we're running out of time? So, if we are to believe your client's allegations, then weren't other people in the constable's office aware of the supposed abetting of violations of probation, because there were other employees who were present who would have witnessed
If they
the
have eyes and
allegations?
ears. Of course, the scriptures say there's none so blind as him who has eyes and won't see. So I don't know. It's in my, and yes, there were others. And there have been other lawsuits. And there are other lawsuits. One pens right now in federal court. But the point is that in this case, Patel reported to Ron, the county calls him her boyfriend. She said there is no evidence of that. But Ronnie Powell said, who was much older than Patel, said that they were friends. They weren't having any sexual relationship. Patel says they were friends. They weren't having any sexual relationship. They were friends because he taught her how to train the staff. She was called. They say that she wasn't replaced by Martinez. That's not true, because Martinez he had the right.
Rest assured, Mr. Watts, we'll be reviewing the record very carefully. We have that all.
Thank you, sir.
So any other questions from the panel? We will recess for 10 minutes and then hear State of Texas versus Sinad.
All rise.